Good
Hi,
morning,
Pete.
John.
So this is financial and estate literacy. Steve came and went there a moment.
And then he disappeared.
It's your estate. I'm sure he'll come back. We probably can get him back in here. Hi,
There
Pete.
he is.
And let me just do a quick share here on some things to get the housekeeping out of the way. I can do this one. So again, financial and estate literacy, it's your estate, fall of 2023. I did it again. I have to keep reading that. As a note, incidentally, there's a couple of pieces that I just want to bring up for you. There's a workbook that we did a few years ago that is available at this site. And yes, Pete, we can go to the website if you'd like to. That will bring up that information. Also, what I did over the off season of spring to fall was write a little thing on estate planning, charitable giving, and financial planning. The financial planning, honestly, is more of a glossary. There are other things in it, but I found that I had pages of glossary. What do these terms mean? So I started doing that. They're all available through the workbook. The other part of this is just from a schedule standpoint, we're doing healthcare and power of attorney today. Then we'll do wills and trusts, retirement planning. And I really want to note the fact that on the 20th, we will not have a session. Then we'll come back to you on the 27th, and then we'll finish off on November the 3rd. Do you want to do the website, Pete?
No, I just wanted to mention that, the outline for today is at iyme.org. And so you can get Steve's, or I'm going to introduce in just a little bit, his Ask First form. In fact, Steve, why don't you go ahead and share screen on the Ask First?
So what I'm going to do is I'm going to disappear. I monitor the Q&A part of this, and I become the person who asks questions, and either I'll answer them or I will ask you guys. So
okay, great. Thank you, Don. And let's see. Well, whenever you talk to an attorney or financial advisor or CPA, you want to know a little bit about them. And so, Steve, can you do your share screen of your Ask First form? And there it is. And so let me, first of all, let you know that Steve is an estate planning attorney, and I've worked with Steve. He's my go-to estate planning attorney for the past 10 years. And so let's go through a little bit. Education-wise, you've got a master's or other advanced degree, and I'm assuming that is your law degree?
Yeah, the Juris Doctor.
Great. And then, but really, does law school teach you anything about estate planning?
Frankly, very little.
Yeah.
You learn the overview of it, but you probably learn more in this series, honestly, than they teach you in law school.
Yeah.
I don't remember ever hearing about healthcare directives. Really, powers of attorney, you kind of gloss over it, but very
little. Yeah. Talk a little bit about your practice.
So our practice involves trust and estate administration, estate planning, trust and estate litigation, and family law. Predominantly, I work mainly on the trust and estate and estate planning side, and another attorney handles a lot of the family law. So we do a variety of different things. Some things are flat fees, some things are most things are hourly, and certain things like estate administration, those are somewhat set by statute, as well as there's an hourly component to certain things.
So I noticed that you're licensed in 2 different states. Talk a little bit about why it's important to see an attorney who's licensed in the state where the property is located.
Yeah, well, not necessarily where the property is, but wherever you have a legal issue.
Okay.
So attorney licenses are all state specific. And so if you're licensed in California, you aren't licensed to practice in Arizona or New York. And it's important because some states have drastically different laws. Like in California, we're a community property state, which is notably different than a lot of states up in the northeastern U.S.
Yeah. So is Washington State a community property state, just for curiosity?
I believe it is.
Yeah. And then the California Bar Association, if you were to be disciplined, would they mark that? Would you be able to find that on your if I were to look you up?
Yeah, you can go to calbar.ca.gov and you can look up any attorney there who's a practicing attorney and see if they have any disciplinary actions, I guess, on their license. And some people do. But.
Yeah, and they continue to practice. So we do that all the time, and we check up on the individuals. Please get in the habit of doing that yourself. You put your client's interests first, and let's talk a little bit about not just how do you charge your clients?
So generally, our fees are hourly, and it depends on who all is working on it. We have different rates for different employees that are working on the matter.
What's your rate, Steve?
My rate is $550. Other attorneys are $400. Paralegals are somewhere between $150 and $200.
Okay. And when you talk about a flat fee, you're talking about putting together a person's will, a person's advanced healthcare directive, durable power of attorney, and a living trust. Is that the package?
Sometimes. So we've switched over to doing a lot more of that hourly, but if someone has a very, very basic estate plan they need, usually we will be open to giving them a flat fee on that.
And what would a flat fee give us a kind of an idea? I'll give you a scenario. I have $1.5 million estate net worth. My house is worth $800,000. I have about $500,000 in investable assets. I'm married, one child. What would be the approximate cost for me to have an estate plan done? And you like me?
Usually it'd be somewhere between $2,500 and $3,000.
Okay. And if you were single, it would be less because it would be probably less documents. Yeah. Okay.
And if I had an existing living trust and needed an update, would you review it and update it and charge a flat fee for doing that, or how would that be handled?
It depends on what it is. So yes, sometimes it is just a flat fee. Generally it's hourly, but usually we do the review and things, like the free consultations we have, so we don't charge people for the initial consultation. And a lot of times people realize they don't necessarily need to change anything. And that's more common usually with people coming from out of state. They think that they may have to change everything because they're in a new state or something like that, or perhaps they have like a trust that they did 20, 30 years ago. Sometimes they don't need to be changed, but other times they will need significant changes to it.
So in that free consultation, then you would tell them what would be the approximate cost to make any changes if needed. Is that correct? Yes.
Yeah. Up with solutions that they may not need to modify anything sometimes.
Yeah.
But.
Yeah. So, and during this period of time when somebody's doing the estate plan, do you charge for emails, text messages, telephone calls, or is that when you do it on a flat fee?
Typically, no, we don't charge for that for the estate plan.
Okay. Yeah. So this is the kind of conversation that you may want to have with your attorney, and make sure that that you understand how compensated, and then and then you want to make sure that the attorney doesn't work with somebody who sells stuff. And as you see right here, Steve said no, false. He does not sell annuities or mutual funds or affiliated with somebody who does. So let's get into the program. We're going to be talking about the two most important documents today that are in an estate plan. And sometimes the advanced healthcare directive and the financial power of attorneys are kind of dismissed as saying, oh gosh, the trust is the most important. Well, I tend to disagree with that. I think your health is much more important, and your powers of attorneys are. So this is Steve's location. He's located in Tustin and recently moved there. And so you're at the heart of Orange County. Let's get you the first slide. Okay, Steve, take over. This is your agenda.
Sure. So we're going to be talking a little, the main subject today is really advanced healthcare directives and powers of attorney. We're going to go over an overview of those things. We're going to touch on capacity as well as conservatorship actions, which are related to these two documents. And I agree with Pete. I think these two documents, the Advanced Healthcare Directive and the Power of Attorney, are probably the most important for everybody because these documents appoint a person to act on your behalf while you're alive.
Even between husband and wife, right?
Yeah.
Yeah.
Yeah, because you may not necessarily want to appoint a spouse in those roles, not for any bad reason, but just for inability to do anything. Yeah. Maybe they lack capacity or aren't comfortable acting in that role. Sometimes that arises more with like blended families, things like that. Yeah. Reduce conflict.
Yeah, but you definitely, they need the power of attorney for someone else's IRA, 403B program, 401k. A spouse just can't get into them. Yeah, you have to have these documents give somebody else legal authority, and that's the key. And if somebody, we're going to talk a little bit about conservatorships later on.
About that.
Okay, let's go.
There's not a whole lot of slides, so
okay. Okay, you tell me how far you want me to go.
Hey, whenever you want to jump in, or if we get
okay,
feel free to jump in whenever.
Okay.
So the capacity is the first topic really to discuss because that's really when these documents come into play. And so you have the financial power of attorney, and that deals with financial decisions. So you're appointing a person to make financial decisions for you. And that can be as broad or as limited as you want. Generally, it's a broad authority that's granted so that the person their hands aren't tied in being able to pay bills, access retirement accounts, assist with government benefits, things like that. The Advanced Healthcare Directive, that's appointing a person to make medical decisions for you and setting up other medical interests that you have. The HIPAA authorization and release grants certain people the authority to get confidential medical information that they otherwise wouldn't be entitled to receive. These come into play when you have capacity issues because capacity, it's always discussed as sort of a sliding scale, right? Really what it means is, do you understand the transaction in which you're engaging in? And that's what I think a lot of people misconstrue when they're saying someone lacks capacity or they have capacity. The difficulty is you can talk to some people and they can be totally aware of what's going on, but when they're reading a contract, they may not really understand what it says. Like maybe purchasing a vehicle, right? It's 10-point font and it's, a 15-inch document you're reading, and who knows what it says. Most people, even that have full capacity, have no idea what it says.
Yes.
But as you get older and you retire and you stop working really for 15 years or so, it does get harder to get back into the swing of things. And that's where capacity issues kind of arise. And sometimes it's better to have designated someone else to handle those more complicated issues for you, just because you are more susceptible to being not necessarily scammed, but entering into agreements that aren't necessarily in your best interest.
Yeah, capacity is a huge issue. The Britney Spears fiasco was all about capacity. Does she have capacity to make her own decisions? When you meet with a client, do you determine their capacity?
To an extent. So attorneys generally aren't tasked with determining if someone has capacity, and there's a lot of public policy reasons for that, because it really requires us to effectively take a position against our client. But I will tell you, doing estate planning for as long as I've been doing it, it's very easy to tell when someone does not know what's going on, or is unable to understand the documents. And sometimes it's a little harder because with the nature of some forms of dementia, people are fine at certain points, and the law does account for that. But at other times, people are so, and I wouldn't say incapacitated, but they just aren't necessarily understanding everything that's going on, and usually it's pretty apparent. And I generally won't get involved in those situations, but some people, it just varies with everybody. Like how many types of dementia do they have? Over 1,000, right? And it's so complicated, and really just is a case by case basis in assessing someone's capacity. So.
Yeah, and this document is in play only during your lifetime, correct? The financial powers of attorney?
To an extent, yeah. So the durable financial power of attorney is in effect during your lifetime, and it's supposed to terminate at your death, but it effectively terminates when everyone is notified of your death. So the Advanced Healthcare Directive, that one is active during your lifetime, but there are powers and authority that go beyond death, such as dealing with someone's remains, things like that.
Okay. Does your next slide deal with the financial powers of attorney? Okay, or do you want to go into the Advanced Healthcare Directive first? Well, whatever the next slide is. So this is the next one, right?
Yeah.
Okay.
So
the
Advanced Healthcare Directive allows you to appoint an agent to make medical decisions for you. And part of that is setting up any particular instructions that you may have in any specific circumstances. Some people want to go very broad, or broad in terms of what they want for like end of life decisions, things like that. You can put other particular instructions as to what treatment you do not want or what treatment you do want and would prefer. The agent is required to, but they're required to follow your instructions, but they don't necessarily always do that because it is up to the agent to make that decision. And that's one of the reasons it's really important to put someone in that role that you trust and are familiar with and believe that they'll actually carry out your wishes.
Let's say the simplified version of the Advanced Healthcare Directive, is that primarily if making the decision for somebody to want extraordinary care, or they still have the choices between A and B? I don't know if that's still prevalent today in your documents.
Do you mean the end, like the end of life decision?
Yeah.
So, so people, you always have the choice. You can choose whether to have your life prolonged indefinitely or not. I've only had 2 people ever want their life prolonged indefinitely. One of them, when they realized what it meant, changed their mind.
Yeah.
But so generally people don't want that, but some people do, and I think it's more of probably a religious-based decision in some cases. But typically people don't want to, and as technology goes on, I think less and less people are going to want that because they probably can keep you alive for quite some time.
Yeah.
Unfortunately.
One of the things is that people worry about when they name someone, if they can still communicate with the doctor, does the healthcare agent step in still, or is that just when the patient can't speak or can't communicate?
Yeah, so that's something that comes up a lot. Everyone wonders if I give them power right now to act immediately, can they just put me in a home? And the short answer is no. You can't put someone anywhere they don't want to be. But 2, the doctors and medical professionals are not going to just ignore you if you understand what's going on and are telling them that you don't want certain treatment. So operationally, no, that really doesn't happen.
Yeah. And how many pages are your documents for the Advanced Healthcare Directive?
Not much. I think it's about 5 pages or less.
Yeah.
They're pretty short. You could actually get there's free. I mean, most medical providers will actually provide.
Next slide. There you go.
Okay. Here's the 3 types talk a little bit about each for me.
Sure. So there's a statutory form, Advanced Healthcare Directive, and it's actually printed in the probate code. And so you can find it in there. I don't know the section off the top of my head, but it's actually
You can
fairly
Google statutory Advanced Healthcare Directive California, and it'll come up.
Actually, I like the form because it's actually very self-explanatory. Most people can just fill it out on their own because it has directions and is fairly clear. There's other printed forms, and different companies have them, will sell them. They're usually pretty cheap. And most of those forms actually look almost identical to the statutory form with just their own little tweaks and modifications.
Yeah,
And then there's
the printed form that if they don't have an attorney drafted one, the one that I usually recommend is the California Medical Association one, only because usually you're in a hospital and the doctors and nurses recognize that form very easily. And so it's available for $10. If does it ever go out of date in this form?
No, it will last as long as someone has it, it's effective. You can revoke it, but it's you don't have to change it. I've had people come in with them after years. Some people will do them 20, 30 years ago. I usually just recommend running it by your healthcare provider to make sure they'll still honor it. And so far, everyone's honored it. The law didn't used to be that way, but typically you don't need to change it unless you're changing the agents or your wishes under that healthcare directive.
The only caution I would give on getting it updated is it's a little bit like stale bread. Yeah, the bread's still there, but it's kind of stale depending on the age of it. And you want to have when you go into a hospital, you're going to have what's called a hospitalist be your medical advisor, so to speak. They're in charge. And so you hand them a document that's 10, 15, 20 years old. They're going to wonder as to what have you recently spoken to the patient that I'm caring for? It's kind of a credibility issue. So I would suggest, don't 3 to 5 years, and they're cheap. I mean, they're very inexpensive. Statutories are free. The California Medical Association one is like $10. So I would say keep it updated. And should somebody keep this document secret, or can it be? I mean, what do they do with it once they completed it?
Yeah, this document generally isn't kept a secret. Usually it's at the minimum given to healthcare providers. The agents should also be given a copy of it, just because they're the ones that are going to need to act under the document. The medical providers aren't going to just have it, and so they're going to need to know who to contact if they need to. And usually before surgeries, after a certain age, they request that you do a healthcare directive beforehand. And like I said, a lot of medical providers will actually give you one for free, I believe.
Every hospital, will hand you one, at least here in Orange County. How about an attorney drafted one? Why should somebody have you do it versus the other two?
So the attorney drafted forms are really when you have more particularized wishes, because you can specify, essentially it's whatever wishes you want are included in there. And so sometimes people have provisions including wanting to stay in their residence, despite excessive costs maybe being incurred. They want more particularized instructions as to healthcare. They want explicitly stated powers. And sometimes that's helpful. It can be. Usually most people are going to be okay with a statutory or a printed form, just because you're appointing someone to make medical decisions for you. And I always say, the more instructions that you give, the harder it may be for someone to operate under the healthcare directive in the future. Just because, one, it could cause confusion if the instructions are a little ambiguous or if there's conflicting provisions. And an example of that would be end of life instructions could say you don't want your life prolonged, but they're also going to, sometimes they can be given discretion to make that decision. And maybe the doctor's saying, hey, they could come out in 3 months of a coma, maybe, something like that. And it just, as time goes on and as medical advances continue, circumstances just change. And I actually think it's riskier to put too specific of instructions to people, because you just don't know how the world's going to change in the next 5, 10 years, even the next 2 years, really,
Yeah, or the next day.
Yeah.
What about, do people mostly have someone in mind who's going to be their agent for healthcare?
Usually, usually they have someone in mind. Typically it's like a spouse or children. Sometimes they'll go to friends or other family members. Some people, rarely do people not have any idea who they would appoint.
How many people should they have in mind? And would you recommend that hey, I got 2 kids and I want to, I don't know who to pick, so I'm going to name them as in other words, co-agents, equal power. What's your thoughts?
Usually I always say a single agent and usually 2 to 3 alternates. Generally, I don't recommend ever putting 2 people into the role of a fiduciary obligation, just because it creates conflict, right? So if there's a dispute about what to do, it's more likely that it's going to end up in court, because if they can't see eye to eye, and if they both have strong personalities, or for whatever reasons, because in this, it's very personal and emotional. So if you're putting 2 children in there, it's risky. And it's risky not only because they might not see eye to eye, but it's risky because over the years, you may have told them very different things, because you may have felt very different at certain points of your life. And this is really common as people get older, because you look at life differently as you get up into the 70s, 80s, and 90s, because I've had clients that, wanted burial until they got into their 70s and 80s, and then suddenly wanted to switch to cremation, that's just one of those things that drastically change. It's a big thing. And over the years, one child may have only ever heard burial, whereas the other,
that brings us to the question is that who in my family controls where I'm buried, or what kind of funeral do I have, or who pays for the funeral? Who takes care of that?
So the healthcare agent is the person primarily that is tasked with disposing of the person's remains and making the decision. And there's an order of succession. It goes spouse and then children. And if you don't have a healthcare directive and you've got, say, 5 kids, there can be disputes about what to do, because it's hard for 5 people usually to see eye to eye. And that's not to say every case. I mean, that's fairly unique. I think that people will generally have such a disagreement that it's going to hold things up and go to court over the disposition of someone's remains, but it does happen.
So your healthcare agents decides as to whether or not you're cremated, whether or not where you are buried, what kind of casket you have, and then who's in charge of paying for that?
Typically, that would be typically the family members will pay for it, just because there's a transitional period more often than not of who has control of the person's assets after their death. And that is either through probate or the trust. And either the trustee or the administrator of the estate will whoever pays. And sometimes, rarely, they will hold off on paying for it until they have authority, because sometimes family members just don't have the money to pay for that.
Yeah, and make sure that they work together, because what you would hate is for your healthcare agent to say one thing and then for your trustee or executor not to disagree and say, I refuse to pay. And that creates sometimes major conflict. Let's go to the next slide.
So these are the requirements for executing it. I mean, you need witnesses. It's an either or. You either need a notary or witnesses. If you go witness, if you have it witnessed, there are certain requirements depending on where you are. Typically, if you're not in a care facility or anything like that, you're fine just getting two friends or neighbors to witness it. You can
They're
also
witnessing the signature. They're not witnessing the document itself. Is that correct?
Yes.
Okay.
Good point. But that's the documents that you have. They're generally going to reflect whatever your wishes are. You want to make sure it's fully filled out. And you also want to make sure you don't change that document as time goes on, because we've had people make modifications to it after it's been signed, witnessed, or notarized. And all it does is create problems and confusion, because if you do that, no one knows that it was you that made those changes necessarily.
Yeah, draft a new one.
Yeah.
Tear up the old one.
Yeah, like Pete said, they're very cheap. I mean, to even get from the California Medical Association, especially, they have a very cheap version of it. So it is just easier to do a new one.
Yeah, and you don't want confusion at the end of your life. The thing of it is, though, is that a lot of these are legal documents. This is a legal document, legal authority. It doesn't really talk about how you feel. And so we recommend highly that you sit down with whomever is your agent and talk about hospice. You talk about morphine, talk about dementia, you talk about other diseases that you may have, talk about board and cares. Getting older, Henny Youngman said that it's not for sissies, and things do not get easier, they get more difficult. And so this document right here is just one of the most important documents in your estate plan. And I think people probably spend the least amount of time on it. Nobody likes talking about death and dying and medical care. So, but you need to.
Yeah.
And you need to, whomever is your agent needs to know what you want, not what they want. You want to have it your way. And there's a booklet called Your Way, and it's on the website that you can, on our financial and estate literacy website, that you can order that booklet that'll help get that conversation started. Let's go to the next slide.
But before we do that, there's been a series of, we've sort of had a run in questions over here that I just thought, let's answer some of these because some of them relate to each other. What options do we have if a family member is in a health facility? Does that affect advanced healthcare directive because someone's in a medical facility? I think one of the questions I would ask two sides of this, and I'm not sure the way the question is, if there is an advanced healthcare directive in place before they go into the health facility, or if they have capacity to implement one, I assume they certainly can do it. Doesn't matter if they're in a health facility.
Yeah, it depends on what kind of facility it is specifically. So in that
if it's a mental institution, they probably can't. Sorry.
Well, you can. So you just have to have other people witness it.
Yes.
Okay. And there's other requirements to it, and you want to make sure you have the right person witnessing it, because you don't want to say, "Hey, I need the receptionist to come witness this," because there's specific people at some institutions that are required by law to be the ones that witness it.
In Orange County, it's
and some that are excluded. Yes.
Yeah.
The ombudsman, for instance. Yes.
Yeah.
Yeah. And that's something you want to have an attorney deal with as well. But in that situation too, it's easier to have the attorney handle it, because people are much more willing to accept it if it is done by an attorney. If it's just done by, in handwriting, and it looks like someone just brought this to them and they didn't know what was going on, there's suspicions will be raised.
Right.
So,
yeah.
Okay.
I've asked Steve to go to board and cares. I've asked Steve to go to hospitals. But just think.
And he keeps
those
escaping each time?
Yeah. What's that?
And he keeps escaping each
No,
time?
no, but each one of those
Right.
situations
Right, is unique.
Is unique and
Right.
also suspect. You know, we've had cases where a board and care operator, you know, was getting their patients to change their documents. So, you know, it's not common, but it does happen.
Okay, if someone is a witness to a signing of a part of a advanced healthcare directive and they move out of state or die, does that void the document?
Wait,
I don't need to worry if a notary dies. I don't think.
are you saying if the principal dies?
The way
No.
it's if this,
The
so I have a
witness.
document and someone has been a witness to this and it's signed off and we're all done, it's in place, and then they either die or move out of state. Do I have to change the document?
The witness requirement, I don't know that I've ever had someone challenge the
witness?
effectiveness, I guess, of a healthcare directive because of the
Okay.
witnesses.
Okay.
It's pretty rare, I think, that someone would challenge a healthcare directive. But no, just because a witness moves out of state doesn't mean you have to redo it all.
Okay.
Or if they die.
If I'm out of state, but I am the person, the agent listed on the advanced healthcare directive, is there a problem if that person is here in California, but I'm not? And Pete, hang on, I know, other than inconvenience and good luck in administering it, you know, can it be done by phone? Yes, but.
Technically, yeah, it can be. But I guess I would say it's more than an inconvenience and just difficulty, because if you have different time zones, you're running into that issue too. But you know, as far as being present to assist the person, some things, and Pete could probably answer this better than me, and there are certain things that you're going to need to be present for.
Yeah, it's just there's nothing like a face-to-face to kind of see what actually is going on versus being told what is going on with the patient.
Okay.
And sometimes, you know,
how many calls have we had where you're sitting in the hospital with someone, right?
Yeah.
I mean, you know, it's just sometimes you got to be there.
Yeah, you just have to be there. I even think that if you name somebody in Los Angeles and they're in Orange County, you know, on a Friday at 3 o'clock, or, you know, try to go, it's a 3-hour drive. And so if you've named a healthcare agent and you're in a long-term care facility, how often will the person visit with you and care about you? And I think you should have somebody local. There are professional fiduciaries in the community that will serve in the advanced healthcare position, and there's probably 60 to 70 professionals in the community. Many of them Steve works with as their legal counsel. Sometimes they're appropriate to serve. If a family member can't be there, the professional should always bring in the family so that there's some closure, there's some feedback. There's lots of highly emotional issues involved when somebody is seriously ill or in the dying process. It's never easy, and that's why this document is so important, and the conversation is so important. If you put on here on the slide the power to donate all or part of your body. You know, there's really lots of different views. I just had an individual donate their body to UCI Medical School, and they took care of all the arrangements. It went very smooth. And one of the daughters was very much against it. And I showed them the letter that her father had written, that's what he wanted. So, you know, it's a highly emotional time for when these decisions are being made. So the more you could talk about it, the more you can give somebody an idea as to what to do. And remember, nobody has died or died and come back and said, gosh, I wish I would have done it this way. So we're all kind of going off on the ledge and trying to do the best possible. And I want to just the comment that Steve made about instructions. You can give generalized instructions, but don't be too specific, because you don't know what the circumstances are going to be when you're unconscious, or whether or not you're revivable, or it's permanent, or temporary. And you ask your agent to do the best that they can, and if they make a mistake, they're forgiven. Because one of the things that happens is that family members sometimes go, come on, you got to fight this. Well, sometimes if you have a cancer or a stroke or a Parkinson's, you know, it's inevitable that you're going to go through a pretty rough time. No matter, it's not about fighting this. It's just accepting it and trying to make the best thing possible. So it's usually a hard period of time for any family. Let's go to the next slide. What is HIPAA?
So HIPAA has to do with the confidentiality of medical information, and me and Don earlier were talking about what that stood for. The health information portability, and I forget what the first A means. In
Accountability.
Accountability, that's the one. And basically, it has to do with the medical privacy. So when you're doing an estate plan, where you have a healthcare directive you're doing anyway, and really with all the others, you should do a HIPAA authorization and release. And the reason for this is not just to give the healthcare agent authority, because they generally will be exempt and will be able to get your information anyway, but you want the other agents or trustees to be able to get your medical information to assist with payments, to assist with providing proper medical care, because they can run into issues when they're trying to make purchases, pay for care, schedule appointments, things like that.
Yeah, it was firstly designed to protect you from the insurance companies. You know, that the insurance company doesn't know your health care and have them make decisions or deny you insurance based on your medical history. And so, but today it applies to everybody. I had an advanced healthcare directive in Saddleback Hospital, but it didn't have a HIPAA release. And so they would not give me the medical records. And the thing, and the problem is that they had transported, she had released herself from the hospital and transported herself to a board and care. And I didn't know where that was, and the hospital wouldn't release the information. So the HIPAA, make sure your advanced healthcare directive has a HIPAA release. The older ones did not. So let's go to the next slide.
Powers of attorney.
Yeah, let's get out of the medical and into the financial. Oh, by the way, before we leave the medical, a couple of things. One is there is a document called the POLST, POLST. This is a
it's on it's on another slide.
Okay, great. Okay, let's go then to the power of attorney.
Sure. So the power of attorney, this is the document where you appoint an agent to make financial decisions for you.
Oh.
And
I'm sorry, it's not informative. I was looking at something else. I apologize. Go ahead, Pete.
God is wrong. Come on. How could that
God's read too many things this morning. I missed it.
Okay, just quickly. There's a form and it's bright pink and it's called the POLST. And this is a medical directive based on doctor's orders. It's for individuals who see the end of life and they have approximately a year to live. and doctor's orders are a sacrament. I mean, they're honored. And so it gives your medical doctor the power to make decisions based on your wishes. So that's really important. The other document is a DNR, do not resuscitate. DNRs are in the last month of life. This is not done, when you're 50 or 60 or 70 and you're in good health. That's just a document that says no CPR, allow me to be in comfort. And then the other two things to bring up on the medical side is please check out hospice care. Hospice care is about comfort, and it's completely different than curative care. Make sure your agent for your health care understands the difference. And and hospice is Medicare paid for, and you can get on hospice and off hospice at any time that you want. So make sure your agent is aware of your prescription drugs, make sure they're aware of hospice care, and make sure that they can follow through on your wishes. Let's go to the power of attorney for financial.
Steve,
Yes.
Would you stop sharing for a minute? I can override you, but I thought I'd be nice and just let you go ahead and actually do it yourself. So hang on a second. I want to show you something that's here. Screen one, share. On the website, incidentally, under the documents, there's a section there's a copy of a thing called What's a Post, and it explains all of what a post is. This is not a bright pink version of it, but here's what, if you want to have it filled out or anything else, it has to be signed by your doctor. Pete and I have a slight disagreement on a post. I am the agent for my sister, my older sister. She lives in Santa Barbara. If you think it's tough to get from here to LA, get from here to Santa Barbara when you are the agent in charge. So she has this on her refrigerator by her choice, not mine, which says, this is what I want done in case of an emergency, giving me time to get there. Is she imminently going to die? No. But it allows her to specify, these are the kinds of things that I want done effectively in the absence of her agent. So this is in there.
Awesome.
There's also a connection in here on your way booklet. So all of those, but I just wanted to point out the fact that if you're curious about a post, there's a write-up on it in terms of on the website. So, okay, Steve, you can come back, bring yours back up.
Power of attorney for finance.
Yeah, so the power of attorney for finance is a document that appoints an agent to make financial decisions for you, and that varies for really any financial matters that you're dealing with, whether it's pulling money from a retirement account or withdrawing funds from a trust that you have, receiving other beneficial interests and other assets or estates of family members, things like that. It can be broad or limited authority. Typically, when you're setting it up in the estate planning context, you can do, it's called a durable power of attorney, and it's a general grant of authority to a person to essentially handle all of your financial affairs.
I thought a trustee handled all your financial affairs.
So the trustee handles the financial affairs for all of your assets that are in the trust.
So
you
got to really pay attention to title.
Yeah, when you're talking about estate planning, title is extremely important because and it's really important. I always suggest to people really pull all of your statements and review them to see how things are titled, because you may think it's in your trust because you set it up 20 years ago and you come to find, oh yeah, that's right, I switched banks 15 years ago and I never did anything. Things like that just happen, life happens. It's always good to review things and similar to what Pete was saying about having a list of medications, it's actually a good idea to have a list of really your assets generally and where you're holding things, where you have things kept, and passwords as well, because if someone else needs to come aboard and essentially manage your life, they need to know what you know. And if it's all in your head, sometimes it's a lot harder of a job for that person to help you.
Yeah. So a power of attorney gives somebody the legal authority to make financial decisions. Do I have that correct? Yeah. Okay. So that seems like a powerful document. Again, you have statutory ones, you have attorney drafted ones. Talk a little bit about those.
Yeah. So there's a statutory form, uniform statutory form, durable power of attorney in California. And much like the advanced healthcare directive, this is a form printed in the probate code. It's also fairly self-explanatory. It lists various different powers, and there are probate codes that deal with each of those powers. And you want to handle it on your own. It's fairly self-explanatory. That one, you need to have it notarized, and predominantly because it has to do with dealing with assets. And so sometimes a notarization may be required for the type of asset.
You have a D in front of the power of attorney. What does that D stand for?
For durable. And so
what does that mean?
That means that it will be effective despite you becoming incapacitated.
So if you just had a power of attorney, if you became incapacitated, it's done with?
Yeah. So what a power of attorney is you're appointing an agent.
So if you go to the next page, it might help.
Yeah, there you go. Explains it all for you right there. But
you,
basically, the agent is like an employee. And so by default, if you become incapacitated, your contract's permanent. And so that's why the durable aspect of the durable power of attorney is important, because you want the purpose of it is to authorize someone to make these decisions when you're incapacitated. There are different ones in limited, and kind of going back one here, limited power of attorney. Sometimes that is a tool that people can use if they didn't set up an estate plan or have very little assets. And what that means is, say you have under 100 grand or under 185,000 roughly for the probate number in an account, and that's all you got. You're renting, and that's the only thing you have. Sometimes you don't have the money and don't want to spend the money setting up a full estate plan, because you know that most, if not all of that, is going to be spent before you pass away. You can do a limited power of attorney, just going to the bank and putting someone on that account as the agent under power of attorney. And that's a limited power of attorney, and it's limited because it's limited to that one account.
We used a limited power of attorney to go on vacation, and we were selling a house. And so we gave a limited power of attorney to a friend, so that they could transact the sale of the house while we were on vacation. That's probably the limited. Does the power of attorney have to use the word durable?
No, it doesn't have to use the word durable. Basically, all it has to have is some words to the effect that it will stay effective despite the principal, which is you, becoming incapacitated.
So please review your document to make sure that it either uses the word durable or that it's effective through incapacity. The next really important point, go back, is what's the difference between, go back to the other slide again, immediate and springing?
Yeah, so immediate means that it's effective immediately. So it's a little bit confusing, right? So the document itself is effective when it's executed. The difference between this immediate and springing is the immediate means the person has authority to immediately start acting as your agent to make financial decisions. If it's springing, then it requires there to be some sort of a determination that the principal, you lack capacity to make financial decisions. And if it's drafted properly for springing, it should have an explanation of what it means to be deemed incapacitated.
What we normally see is that a doctor has to, in writing, declare that you don't have the mental capacity to handle financial issues.
And you generally want it to probably be a single doctor, only because, as Pete, I'm sure, can tell you, if you get certain types of dementia, you stop trusting the people closest to you. But two, if someone says you're incapacitated and you don't believe it, well, no, I'm not going to get a second opinion because he's wrong. You become rather resistant in certain circumstances to seeing a doctor. And if you can't see him, the doctor is not necessarily going to write a letter stating that this person lacks capacity because they haven't seen the person. So.
Yeah, a lot of times when with dementia patients, the person who's closest, who's been caring for the individual, becomes the absolute outlaw. They feel that hey, you're trying to restrict me. Mentally, they literally will accuse the individual of abuse many a time. So and then another family member steps in and doesn't know what to think and takes them maybe to another doctor. And so do you normally, for people 70 and above, do you normally do the immediate or do you normally do the springing?
Typically we do immediate, and the reason we usually recommend it is because if you trust this person, which you should, it shouldn't be an issue, right? If you don't trust them, that's a concern, and you probably shouldn't be putting that person in this position.
Yeah, and the practical uses, okay? If you're having to cancel a credit card, well, they want to first see whether or not you have the legal authority to cancel somebody else's credit card. Cable TV, same thing. They want to know, do you have the legal authority? Cell phone service, same thing. If you need to get into a spouse's IRA account or their 401k, first thing they're going to ask, do you have the legal authority to get into that account, because your name is not on that account.
But if I have full capacity, I have the ability to cancel any of these as long as I have the capacity to do so.
Full capacity or
springing, immediate, any of these things, right?
Okay. Yeah, exactly. And then the financial institution will determine, they'll usually send that document to their legal counsel to see whether or not it's appropriate. So many a times, Bank of America is one, Wells Fargo sometimes does the same thing, public employment retirement system. They want you to use their companies or their banks or their financial institution or their insurance company power of attorney form. Steve, you want to comment a little bit on that?
On using their forms?
Yeah.
Yeah, the difficulty, I guess, is you want to trust them because they sometimes have been your advisors for many years. The problem that I've run into and just seen clients dealing with is they're not really attorneys, and sometimes they're trying to maintain the business relationship, and so they're sort of trying to accommodate their clients, which you can't fault them for that, but really they're effectively practicing without a license if they're telling you to do estate plans and things like that. And a lot of times that's where we see issues that arise in the administration, is because things aren't drafted properly, or they weren't executed properly.
So one of the things that I recommend highly that you do is to take your durable power of attorney that your attorney drafted, take it to your brokerage firm, take it to the insurance company, take it to whoever handling your IRA, and see if they will accept that form and put it electronically online. Just remember that, later on, if you change their document, that you go back and, change those forms, because if you have a document that's over a year old with Bank of America, they're just not going to accept it. And so Steve, as an attorney, can force them to accept your document, but it's not going to happen overnight. And sometimes you need the monies to pay for medical care, to pay for the cable TV, to pay for what insurance, food, etc. and your only document is the durable power to get at that checking account, and it causes a lot of grief. So it's best to take it to your institution and have them put their okay on it. Let's go to the next slide.
Except that he's going to ask a question. So this is somewhat more of an executor question, but I'm going to ask it because it's come up here. Do I have to notify, someone's passed away, I have a death certificate. Do I have to notify credit agencies that you're dead so that nobody else can apply for credit or anything else on your social security number? Or how do you handle that?
Typically you can, but your credit is actually tied to your social security number. And so once you're deceased, they will be aware you won't be able to pull credit on a deceased person, I don't believe. Yeah. I'm sure there's a way to do it if you try really hard, but yeah, it's all reported through the social. And
not surprisingly, Social Security finds out that I'm dead through a death certificate being produced by an authorized agency.
You are, if when you die, it becomes public knowledge.
Right.
And so it's registered with the county.
Okay.
It's available to anyone. And there are search firms out there that keep track. And so if you are going through probate or there's a death, all of a sudden your mail becomes different, you know, you'll go into a different industry. The dying industry is huge.
Big. Yeah.
Big. Let's go to the next slide, Steve.
So selecting an agent, this is probably the most important detail of your advanced healthcare directive and also your power of attorney for finance. You want to make sure it's someone that you trust, but also someone that is capable of taking the actions that need to be taken under whichever document. So typically that people will put their spouse in. Usually that makes sense and it's feasible. But sometimes a spouse is probably not the best person put in control of finance. And it's something that you really have to do some self-reflection with a lot of these documents and see who's the most appropriate person to put in this role.
Or even medical care. And my own situation and family, my mother was just the worst individual to be named because she thought doctors walked on water and she couldn't handle going to a hospital or even to a doctor's office. So she realized that. And so she didn't take it personally when she wasn't named as the agent. But you got to have that conversation and make sure if you name one individual for your health care and the other person, another family member for your finances, do they communicate? Do they get along with one another? Because they can use this to get even. And a lot of times when somebody becomes ill or dies, the parent has lost control and then things revert back to adolescence and they get sometimes pretty petty. But who you pick is absolutely important. How about a friend?
To the friend, and I was going to say, if you're on the other side of it and the person being requested to be an agent, be honest with the person requesting you if you think you can actually do it. Because a lot of people want to do it out of they feel like a familial obligation, or for example, a friend, they got no one else, I want to do it. But people don't really understand the nature of what they're agreeing to do. And if they can't physically do it, or just it's too much to handle mentally,
it takes time. It takes
really
time.
Yeah, it does.
You know, just to change and talk to the cable TV. I mean, I have spent over an hour and a half on the phone. You know, dial push 1, do 5. What's your PIN number? You know, it's just kind of crazy. And a friend is exactly what you said, Steve. Their reluctance to say no because they are your friend and they want to help, but they just don't understand the amount of time and work that's involved. And then what does the probate code 21380 mean?
So that has to do with caregivers and giving automatically disqualified gifts to certain people. So if someone is an agent under any of these documents, they can be considered a caregiver because they are providing care. If it is a friend who is also a caregiver and you think, oh, they won't get anything, but they'll receive something under my trust, you really want to speak with your attorney and make sure that that's clear what their relationship is and what they're doing. Because if you don't, the gift to them could be nullified later on because someone could challenge it saying, hey, they took advantage of my aunt or my mother, whoever, not realizing that was the arrangement that was made before anything occurred.
Yeah. So if you're going to name a friend or a caregiver, or you're going to leave them a gift in your trust or will, make sure your attorney knows about it. And the attorney many times will recommend what's called an independent review. And what is that, Steve?
It's a certificate that the attorney signs, and what they should have done is really make sure that this gift was not the result of undue influence, because that's what it's certifying, and that you actually wanted to do this.
And that's done by a separate attorney. Let's say if it was your client, another attorney would actually come in and interview the client.
No, typically it can be done by the attorney unless there's some sort of a conflict or other issue there. Or, you know, it's the attorney themselves, obviously someone else has to do it. But yeah, it's something to be aware of, and don't, you know, I have clients that sometimes will get a little bit annoyed because I'll start asking questions about healthcare directives and things. And sometimes people, they think that it's a sales tactic, right? It's like, oh, he's trying to upsell me documents, but really it's, well, I want to know, because if you're leaving these people gifts, there's a concern here that it might be invalidated later.
Yeah.
And that's something to really be cautious of. Don't be afraid of telling the attorney that if you have an attorney assisting you, because it is something that they need to know, because it's, you know, all of these estate planning documents really act together, and you can't do them in a vacuum.
And do you ever get asked to serve as an agent for somebody's healthcare or for their power of attorney for finances?
I do, and I generally decline. It only because it's really, you know, people think there's, for whatever reason, and I don't know why, but people think attorneys would be the appropriate people to put in these roles. But it's really a very different scope of work of what attorneys do versus what these agents do. In my business, I do not regularly make medical decisions for people, and I do not regularly make financial decisions for people. Very few attorneys do that. And that's why it's generally not a good idea to put them in. But also the time devoted to these types of things, like Pete knows, I mean, there is a lot of time, and attorneys are probably the least likely people to have the time to devote to that kind of stuff.
Yeah. Yeah. And that's one of the questions that you need to ask even for your family members. If you, let's say you had a really sharp daughter who is the CEO of a company, and you go, gosh, you know, she's smart, she's cares for me, she loves me, blah, blah, blah. The question is, does she have the time to put into this? You know, can somebody be named in a document after you lack capacity? In other words, can a person be named in as the agent for a healthcare or as the attorney in fact once you lack capacity?
So the short answer is no, but this is where it goes back to the sliding scale aspect of it, right? So I've had people that definitely could not have executed a trust or done more complex transactions. And when I say more complex transactions, think about buying a car or buying a home, right? There's a lot of details to those transactions that you have to be aware of and understand. But it's a very different level of understanding to say, do you want this person to assist you in bill payment? And it's a much simpler transaction that you're engaging in. And even the scope of that depends on how complex of authority you're giving them. So the short answer is no. If you absolutely lack capacity, which means you would not understand the nature of what you're doing, you can't do it. But that's why I say it's important to kind of understand the distinction there, because it really is a sliding scale. And these days, because of a lot of the changes in conservatorship law, it's likely the courts would uphold a lot more of these informal documents if someone is suffering from dementia but has sufficient understanding of the document that they're executing, because the courts are becoming a bit, I wouldn't say more cognizant of it, but they're just being more thoughtful of the public policy against conservatorship.
Yeah. And we're going to talk about conservatorships in just a little bit, but Don has a question.
So is there any danger in code 21380 applying if a named caregiver is the beneficiary of the account?
Ooh, huge.
Yeah.
Yeah, there is. So you
Yeah.
could do a certificate of independent review. You could speak with an attorney about it. I mean, there's other ways of handling it. It's, you know, it's one of those things where, and that's the reason I do free consults, right? Is because people have unique issues like that where you may not necessarily need an attorney,
Right.
but sometimes it's just good to get run it by someone who is familiar with the situation, because
We have just
And yes, and you have 10 minutes.
okay. We have a situation where a 96-year-old went to Tahiti with his caregiver, and just, you know, I mean, she cared for him, but you know, at the end, he wanted to leave his entire estate to her. And I could understand why, but at the same time, you know, I said, Bill, you need to speak to your attorney if that's what you want to do. And the attorney basically talked him out of it, and appropriately so. So those situations arise all the time. So
And he died on the flight to Tahiti.
yeah, he died on a flight to Tahiti. And he died very happily and peacefully and without pain. So he had great thoughts in mind of his vacation. Talk a little bit about, we're going to go into naming professional individuals in the last session, session number 6. So I'm not going to spend any time in that. Steve, you have number of professionals that you deal with, and that you can recommend to people if they come into you and ask if to make a recommendation. So unless you want to say, do you have anything else to say about that? No. Okay.
conservatorship.
Let's talk about conservatorships.
So conservatorships are the default government versions of the power of attorney in the Advanced Healthcare Directive. They are vastly more expensive, time-consuming, and just generally not fun. They're not fun for anyone involved. Most people don't even realize the expenses they incur when they initiate conservatorship proceedings. And so that's really what it is. So a probate conservatorship, what that is it's someone that doesn't have estate planning documents, generally, and there's no other alternative. And so the court needs to appoint a person to make either or both medical and financial decisions. And you could have limited conservatorships. Those are for people that have a developmental disability. Typically that's from birth or a very young age. And then there's LPS conservatorships, which is similar to limited, but it's much more controlled. So LPS conservatorships are year-long. They have to be renewed annually. And the purpose of LPS conservatorships is to deal with persons that have mental disabilities that create a danger to themselves or others. And they're very sad situations. They're very difficult situations to deal with, because you're dealing with someone that doesn't understand what's going on and can become violent. So you're dealing with that. Very difficult situation. Hopefully no one on this has to deal with that, but they are out there. And unfortunately, our state does not have enough funding to really adequately fund the programs and the government agencies needed to assist people in those situations.
Very sad. Very sad. But the common thing is, let's say a husband and wife, husband dies and the vast majority, let's say all of his assets were in his IRA account and no documents and no power of attorney. And he has a trust, but no powers of attorney. Didn't think they needed one. What happens? How can the woman possibly get into that IRA account to get the money out?
Conservatorship is the short answer. There may be some limited online access, but
and how long will that take?
The conservatorship action, it'll take a minimum of 6 months to get someone appointed, usually, and that's if it's uncontested.
Quick. That's quick.
Well, they're doing it quicker now.
Oh, yeah.
Like I said, that's probably the minimum you're looking at, and that's assuming everything goes smoothly with it.
Smoothly,
not always the case.
Yeah, and it costs 10 to 30,000
at least. Yeah, and so the reason it's so expensive, right, is because most people are going to have an attorney appointed for them. They might have another professional appointed for them in the court proceedings, and so the fees on the case can go up fairly quickly, depending on the person's condition. They could choose to oppose it, and then you're looking at a lot more of an expense. Generally, if you can resolve it outside of doing a conservatorship in some way, it's usually recommended. But unfortunately, that's not always the case.
So, moral of the story is a little bit like the Midas. I think it was Midas that had said at one time, you can pay us now or you can pay us later. This is kind of that situation. Make sure you have this document and it's accepted by the financial institution that you're working with. We have about 5 minutes to go. Steve, is there anything else that you want to bring up before we open it up for questions?
If anyone has questions, I can answer.
Okay, so the conservatorship of the person is kind of like your advanced healthcare directive. And your conservatorship of the estate is kind of like the durable power of attorney for financial matters.
Yeah, and the reason these are also more expensive is because under both of those, you generally you're supervised by the court, essentially. And so you have to get authority from the court to do a lot of different acts. Yeah. And whereas with the power of attorney and the healthcare directive, it's contract-based. And so you've already agreed that this person has this authority, is effectively the theory behind it. And that's why they're granted much broader authority.
Yeah. And nobody enjoys being under conservatorship.
Nope.
Even the professionals.
I was going to say, with a conservatorship, you lose control over your account, whereas with a durable power of attorney, you still can write checks.
Yeah. It's that's why we consider. Hopefully, you got across how important both these documents are, and how important. By the way, how many succession individuals should you name in these documents? And is there a limit?
There's no limit, but I usually recommend 2 to 3.
2 to 3 individuals. So if one can't serve, the second one steps in.
Yeah.
Okay. Let's Don, you want to come online? And
Steve's going to go to the next page.
Steve goes to the next page.
Oh, look, that's a thank you. What a coincidence. That worked out well, didn't it?
And by the way, Steve has volunteered.
Yes, Don's following along. Yes,
yeah.
Yes.
Steve has volunteered his time, so we really appreciate you spending it with us, Steve. Thank you.
No problem.
Now you can stop sharing it.
Okay.
Because if they need it later, they can either go to the Ask First form or for that outline on the website that's available to them.
Yeah. If anybody has any questions, please pop up and write one. And if you don't, that's okay too.
We've answered a whole lot of them along the way.
Okay, great. Then Steve, thank you for being here. Don, as usual.
Thank you.
Great job.
Thanks for having me.
Yeah. And
this has been Financial and Estate Literacy. It's Your Estate, fall 2023. It's really going to take me a year to figure this out, what year it is.
And then
It's
it's
a
going to
good-
be 20, then it's
it's
going
a-
to be 2024.
It's a limited capacity thing because my birthday for 74 next month. Anyway, so this has been week 2. We've been talking about, obviously, advanced healthcare directives and powers of attorney. Next week, we'll start talking about trusts and wills.
Yeah.
Or wills and trusts, depending on the order you want to go through it. So thank you all for being here. Pete, it's been delightful. Steve,
Yeah.
good to see you again. And we will persevere. We will be back next week. Thank
Okay.
you very much, all.
Bye-bye.
Take care.